teaching them. But I wanted to get into real estate right out of high school until I figured out what else I wanted to do. And here we are 42 years later. I'm still trying to figure out what I want to do. So with that, today we're going to talk about, we're going to go through a lot of material, okay? And what normally, this is something I used to do in 16 hours, and we're going to try and cram it in 2 hours. So I'm only going to talk about the national portion of this, so no matter what state you're in, it's going to apply. But also, I'm going to talk about some of the questions that are going to be on the exam, the national portion of the exam. What are the most common questions? And we're going to spend about 10, 11 minutes per chapter. There's 9 chapters. And then we're going to go over a math formula, and then we're going to take questions and answers. If you have something pressing, you could certainly interrupt me. Otherwise, there may be a possibility or the likelihood that I will answer your question if you just let me go through the motions here and present this. So without further ado, let me go ahead and get started and just follow along as you go with me here. The first chapter is about property and what they call property, estates, and ownership. You see, ownership is not really a physical thing that you could have. Ownership is defined by law with what you could do with the item that you have. So for example, this is what we call a bundle of rights, by the way. You have the right to use, you have the right to occupy, you have the right to leverage, you have the right to transfer, you have the right to encumber, you have the right to destroy if it's free and clear and no lender or nobody else owns it. So these rights make up what ownership means in North America and in most of the world. So it's not really defined as a physical thing, but by what you could do with it. And that's the premise that we're going to talk about today. So the right to use, could use it any time, possess it any time, transfer. You can sell it, you could put money on it, you can borrow money against it. And enjoyment, you can enjoy it, what they call quiet enjoyment of possession. So that makes up the bundle of rights, which legally defines ownership. So when they ask you what is an ownership, you want to look for the answer that has any one or a combination of the things we just mentioned being the bundle of rights. The way to own property in North America, well, actually, most of our laws, by the way, come from the English common law. On the eastern side of the United States, we have some laws that come from Napoleonic rule. On the western side of the United States, a lot of laws come from Spain, being that Spain occupied that part of the world. But the feudal system is one person monarch or king, or one person owns the entire land and everybody else is subordinate to them. We don't have that here, but they still want you to know it for the exam. The allodial system is which individuals have the right to own real property. That's one of the systems that we have here. Real property includes the land and anything above it and anything below it. So let me expand on that. When you buy a house, for example, or when you're representing a buyer, for example, as an agent, you are helping the agent buy that house. But what else are they getting? Well, first of all, it makes sense that they're getting the land itself, okay, unless it's a land lease, but those are exceptions. They get the land itself. They get airspace, what they call airspace, to a reasonable point above the land. For whatever reason, you can build, as long as the city allows it or no restrictions, you can build a high-rise on it if you want, subject to zoning laws, etc. But you also get what's underneath the land. You get kind of a pie-shaped piece all the way to the center of the earth. What are you going to do with all that? I don't know, but that's the law. You get not only above ground, the airspace, but you all the way down to the center of the earth. And more importantly, anything contained in the subsurface. So if there's oil, gas, minerals, there's diamonds in there, there's gold. If you hit it, that's going to be that's going to be up for the buyer to keep, and they could do all sorts of things with that. So when real property is defined by the land and anything on top of the land, what we call improvements. So let's talk a little bit about Attachments. When somebody buys a house, when you're the agent representing someone who wants to buy a house, you not, of course, you get the land, but you also get the house. But in addition to that, you get what's called attachments. And attachments are anything that is affixed to the land or the house itself. So for example, if the homeowner who's selling the house put a fence on the property, guess what? That is now considered part of the property itself. And we're going to talk about real property versus personal property as well, because there's a difference between the two and what is conveyed and what is not. So improvements are anything, houses, fences, you put in a swimming pool, anything resting on the land that is a permanent nature or that is be kind of tough to remove. So for example, a tree is considered an improvement. It's attached to the land. It's a fixture. It's a fixture that is used, it used to be personal property, and now it's real property. When you had a seed in your hand that is personal property, you put it in the ground and add water, now it becomes real property as a tree. But remember that real property can become personal property and personal property can become real property. So you have to be careful and aware how they say that on the exam. So for example, if you have a bunch of lumber sitting on the land there, is that personal or real? Well, that's personal property. It's not affixed to anything. Take that lumber and make a fence out of it. Now what? Now it's real. You take that fence and you destroy the wood, and now it becomes what? Real again. You start a fire. That's personal again, I meant to say. So real can become personal and vice versa. The actual trick is what is called a fixture, and we're going to talk about how they determine what is a fixture and what's not. But just for now, realize that a fixture is anything that used to be personal property and now has become real property. The mnemonic on a fixture is adaptation of the item and agreement of the parties, intent, and method of attachment. So let me give you an example. And those are three things you need to remember. Let's say that you show somebody a property and there's a beautiful chandelier in the living room. And the buyer looks at the property, they look at the chandelier, nobody said anything about wanting to keep it. The seller, the other agent didn't say anything. You know better, but for whatever reason it was missed. Nobody talked about the beautiful chandelier. Here comes the walkthrough a day before closing or day of. You walk in and the beautiful chandelier is gone, and now it's replaced by a Home Depot special, $49.99. And now the buyer's saying, wait a minute, now you have a problem. Was this permanent? Was it personal property? Was it real property? Well, one way to avoid that is to, of course, put it in the contract. And at that point, whether it's personal or real, chandelier will convey with the property. But absent that, somebody's going to have to figure out if it's considered real or personal. So one of the methods they use is adaptation of the item and agreement of the parties. Okay, what is it used for? Well, a beautiful chandelier is sort of attached to the ceiling, which has become part of the property. They will look at that. What was the intent of the parties? Well, absent any other agreements, the intent was to sell the house with the chandelier. Potentially, that could be a way to look at it. But if it ever goes to court, that's what a judge is going to look at. Method of attachment. Was it permanently attached to the house itself, or could it be easily removed? If you can just take a couple of screws and take it out, how easily is it to remove that? Go back to the fence. Well, a fence we know is not easily removed. The intent is, chances are, nobody's going to take a fence with them. So left unchecked, it's going to be real property. So just be careful that a fixture is anything that is attached to the land or the structure itself becomes part of what you're conveying. There are exceptions to that, and you need to know this. One of them is trade fixtures. So trade fixtures, let's say that you're selling a restaurant, okay? You're selling the building, and you're not selling the business itself, but you're selling the building. And trade fixtures are going to be the oven, the countertops, the shelving, cash registers. All those are personal property by nature, but in this particular case, they're not considered trade fixtures. Why? Because they are part of the business, and they generally um, do not convey with the property. Just make sure that you know that exceptions are the trade fixtures. Growing things. Of course, anything that grows on the land is for the homeowner. Okay. There are two types of what they call emblements on there. So growing things has two types. One is what they call fructus naturalis. That's a Latin term. And yes, they use Latin terms on the exam. Fructus naturalis, which means that the fruit of nature is what it's called, meaning they're natural things that grow. They're, like trees, wild trees, shrubbery, weeds. All these things are fructus naturalis, as opposed to fructus industrialis, which means in Latin the fruit of labor. Fruit of labor is anything, for example, that a farmer would plant. So crops at the end of the season, when the crops come, and they start to collect it, well, those are called fructus industrialis. Why they want you to know that, it's been a mystery to me for over 40 years, but that's okay. That's what you need to learn, those two terms. I don't remember the last time I heard an agent say fructus industrialis on a contract, but that's something that you do need to know. Let's talk a little bit about personal property and some of the estates that are available to us. What is an estate, first of all? Well, an estate is a right of you owning the land. Remember the bundle of rights? Well, there are different types of bundle of rights. And the most common type of bundle of rights falls under freehold estate. Freehold estate is one of the highest degrees of ownership. Sometimes it's called fee, sometimes it's called fee simple, sometimes it's called fee simple absolute. So those three terms mean the same thing, and that those define the freehold estate, and they complement and supplement the freehold estate. So anytime you hear the word fee, just think that you have the highest degree of ownership. Another degree of ownership that's not as high as fee, not as complete as fee, is called the life estate. And a life estate simply says, let's say you're representing a buyer, and they go into the house, and they one of the conditions is, well, grandma's going to live in the house until she passes away, and once she passes away, the property will then convey to a particular person. So the life estate depends on someone's life, literally, and that's how they measure it. So remember that a life estate is tied to someone's life, and it could be done in many, many different ways, but that's how they put it together. So the holder of the life estate is called the life tenant, a life tenant. All right. The next thing is less than freehold estates. Legal life estates. Those are things that we don't need to cover. That it hardly ever comes up. Homestead does come up. A homestead is a way where a certain state, it's really state specific as to how and how much, etc. If you record a document, and sometimes you don't even need to record it, it's called an automatic homestead, everybody has protections from creditors up to a certain amount. So what that means is no matter what happens, whether the property is foreclosed on, whether not foreclosure, but let's say that anything happens to it, it's gone, it's just not there, earthquake happens, or you are protected, your equity is protected up to a certain amount, And that varies by state, and it also varies as to whether you need to record the homestead document or not. So they used to be real ridiculous amounts in most states, but they've updated them recently to kind of stay with the ages. But that's what a homestead is. It protects the homeowner's equity from creditors, foreclosures, etc. So remember, the highest degree of ownership is fee, fee simple, or fee simple absolute. They all mean the same thing. There's also another type of estate that someone could have in real property, and it's called less than freehold estate. Less than freehold estate, as the name implies, is not quite fee. That means there are conditions, they're subject to major contingencies. For example, when you rent a property, if you're representing a person who's going to lease a property, that lessee, in a lease, by the way, you have a lessor and a lessee. You have somebody who's going to be the landlord, somebody who's going to be the tenant. Lessor is the landlord, lessee is the tenant, and that applies to a lot of titles that we're going to talk about. But in a less than freehold estate, it usually applies to somebody renting a property in various ways, various lengths, and we'll talk about that here in a second. But it could also be a license. So I'm going to give you a license to come hunt on my property between, you know, the months of hunting season, or I'm going to give you a license to come on my property and go fishing. That's a temporary window in which you could use the property. When you go somewhere to a venue and you park there, that is actually a less than freehold estate, believe it or not, because you are occupying that premise for a very short period of time, and you have permission to do so with the owner's blessings. So let's talk a little bit about the types of leasehold estates. There are various ways that someone could have an interest in a property on a lease. Let's talk a little bit about estate for years, and these are terms you're going to have to know, folks. Estate for years, that means that, and I know that it sounds like it's for years, but it's not. It's for a fixed and definite date. So estate for years has a definite termination date. Okay, that's number one. Periodic tenancy, period to period, usually a month to month. So think month to month when you're talking about periodic tenancy. That's easy to remember. Periodic, month to month. Tenancy at will. Tenancy at will exists when there's absolutely no lease, nothing written, and the owner's there, the owner's letting a person occupy the property. But guess what? It's exactly what it means. Tenancy at will, meaning the owner can come anytime on their own will, on their own accord, anytime they choose, and tell the person they're no longer welcome in the property. That's called tenancy at will. Of course, we don't like that. We don't use those in our industry, but that's something that you need to know for the exam. Tenancy at sufferance is when somebody had a lease, but it expired, and they're still occupying the property. Okay, whether they're making rent or not, it's irrelevant. But if the lease ended and they're occupying the property, that's called tenancy at sufferance. And just think the landlord is suffering at this point. Okay, and they either, you know, stay with it, make it month to month, or they just let it ride, and as long as they're making payments, it doesn't matter. But tenancy at sufferance is there was a lease on the property, it expired, and now we have a tenancy at sufferance created. The possessory right to occupy the property is granted by the lease as personal property. So that lease itself is not really real property. You just have the rights to occupy that, and they consider a lease personal property. Let's say that there's the other thing you need to know, if there is a sale of the property, the owner can sell the property anytime. They don't need the tenant's blessings unless there's an agreement not to do so, or an auction or something. But absent that, the landlord could sell the property anytime, but the new purchaser, the new buyer, is going to take over the property subject to the lease. In other words, they can't kick out the tenant. They can't increase the rent. The terms of the lease apply for the duration of that lease, no matter for the duration of the lease, no matter who owns the property. So yes, they could sell it. This is actually a pretty good deal for somebody who's willing to invest in real estate. They want to buy a house and they want to rent it out, but there's a built-in tenant. It's like, fantastic, you know, we don't need to go and look for a tenant. So they just keep them there and they keep renewing the lease. That's one model that exists. In the case of foreclosure, when a bank forecloses, it used to be that they can, give notice, and the former, let's say there was a tenant in there and the property was rented, and now the property has been foreclosed on. You'll be surprised a lot of times the tenant doesn't know. But prior to 2009, 2008 and 9, when we had the financial meltdown, the lender can willy-nilly kick them out. But now there's laws against that. They passed those laws back then, and if you have a fixed lease, it's you can continue for the duration of that term. Let's say that your client leased the property for 1 year. First month the property was foreclosed on. Well, guess what? They're going to allow the tenants to possess the property under the lease. If month to month, because of what happened back then, and a lot of people were losing properties, the law still applies, PTFA, that the tenants have 90 days. They're allowed to have 90 days to do that. So these are, and they keep renewing that law. So just keep that in mind, that it's still there. Types of ownership. There's really two types of ownership that you could have in a real property. One is sole ownership and one is co-ownership. Those are the two major categories. Sole ownership, own it by yourself, or co-ownership, you own it with others. That's really the only two ways to hold title to property. So separate ownership is a leasehold in real estate for the duration of the tenancy. Now, the sole ownership is an individual. It could be an individual, or it could be a legal entity. A legal entity, which we're going to talk about in a second, can own real property under certain conditions. But for example, the single man, single woman, unmarried man, unmarried woman, married man, married woman, or widow, widower. So you could still be married and have sole ownership of a property. You could still, you could be single and own it. It means that one person or entity owns the property. That's what sole ownership means. Co-ownership is under, well, first of all, before co-ownership, let's talk about entities. Entities like corporations or LLCs or partnerships even could own real property. And they could own it as just a sole owner. It's the only person or entity on title. Those things are called legal entities. They call that a legal person. So you have a legal person is another way to, if you hear that term, they're talking about an entity that is possessing real property. Co-ownership is when two or more people own the property. It could be two or more people or two or more entities. So for example, you have two LLCs buying a property, and I had a question on that not long ago. Can two LLCs own a property? Absolutely they can. Two LLCs can own a property. It's called co-ownership, but there are some restrictions to that, and I'll get into that in a minute. Now, when somebody acquires title to real property, they're going to have what's called the vested interest in that property. And how they define that interest is very, very crucial. And by the way, if you have anybody asking you, a buyer or a seller or anybody asking you, how should I hold title? Okay, well, you can say tenancy in common, joint tenancy, community property, or tenants by the entirety. That's it. Because if you advise them how to do so, even though you know it by heart, that's considered practicing law, and you don't want that liability. But let's get into what they mean. Tenancy in common. Tenancy in common is for two or more people that potentially want to have undivided, they have divided interest, unequal shares in the property, and they want their shares to be willed. So for example, if you have two investors, well, they're going to have, let's see, one is 30% interest in the property, one is 70% interest in the property. That's the only way that they could hold title out of the four, because everything else is equal. So when you have two of them, tenancy in common. With tenancy in common, you could have unequal shares. They could sell their interest in the property, and they can will it. subject to a will. That's tenancy in common. Joint tenancy is a little different. Joint tenancy is when two or more people, and a lot of times it's husband and wife or family, depending on the circumstances. Joint tenancy is when two or more people own the property and they have equal shares. There is no undivided interest in that. Equal shares. Each one of them has the right to occupy. Each one of them has the right amount of equity in the property. They both own it equally. With joint tenancy, however, there is no wills. They cannot will their interest. Even if a will exists and it says that, it's invalid. Joint tenancy, what happens is when somebody, you have two people on title, one of them passes away, title immediately passes on to the surviving owner. It escapes probate, it escapes all that. So joint tenancy is really good for maybe families, is good for husband and wife, is good for all sorts of situations that are like that, where it's not going to be in a will and it wouldn't matter. Joint tenancy is not good for investors, because if you're an investor, you have your own family, you have your own money, and they're two separate things. You're just in on a venture to make money in real estate. That's joint tenancy will probably not cut it. But that's not up to us to tell them. That's up to their attorneys. Community property we don't have out here. On the East Coast, most states don't have community property, but that's mostly on the West Coast. That comes from the Spanish laws, the community property, which gives spouses interest in real estate. That's all I'm going to talk about because it's irrelevant. Tenancy by the entirety. Tenancy by the entirety is only for husbands, and it's for spouses. Okay, it's for spouses, and you can't have undivided shares. So everybody owns an equal share of that, and you basically cannot will it. And title will pass on to the surviving spouse. But the difference between joint tenancy and tenants by the entirety is that, and it's not in every state, but it's in a lot of states, the difference between joint tenancy, so far they sound alike. You have undivided, you can't have undivided, it goes to the surviving person. One is for anybody to use joint tenancy. Tenancy by the entirety is only for spouses. The one thing that you get with tenancy by the entirety that you don't get with joint tenancy is protections that are afforded to you from involuntary liens. And later we'll talk about involuntary liens. So, for example, if somebody goes out and does some work on the property, you don't pay them, they're going to come and file a mechanics lien on the property, what they call a mechanics lien. Well, that's an involuntary lien. Certain amount of equity is protected by those liens. So that's the difference between joint tenancy and tenancy by the entirety. Is for tenancy by the entirety is spouses only, and some of the equity is protected from involuntary liens. Voluntary liens are a fair game. So the only involuntary lien that is not subject to tenancy by the entirety, and you got to remember this, guess who it is? The IRS. The IRS doesn't care. Your equity is not protected. They don't care how you hold title. They're going to come and take the property if you owe back taxes. Okay, if that was their only resort. So those are the differences between the four vestings, as we call them, and how people hold title to real property. But then again, this is not up to us to tell anybody. This is up to the individuals to go see an attorney and figure out what. And I can tell you story after story of agents being sued for that, where it's not pretty at all. All right. In joint tenancy, there's something called TTIP. That's the mnemonic, TTIP. In order to create joint tenancy, you have to have those four items, and you need to know them. Number one, title. All parties must take title at the same deed, on the same deed. One person can't come on this deed, and another person can't come on another deed later. It has to be done on the same deed at the same time. All parties must become joint tenants at the same time. We just said that all parties must have equal undivided interest in the property. You can't have 60-40, you can't have, it's all 50-50 undivided. All parties have equal rights of possession, as we discussed. So remember TTIP. Tenants by the entirety, we talked about that. It escapes probate with the right of survivorship. And again, undivided interest. And the only difference between joint tenancy and tenancy by the entirety, two differences. One is that by the entirety is for spouses only. Two, some of the equity is protected against involuntary liens except for IRS liens. Recording ownership. All right, let's talk a little bit about that. Recording ownership, when somebody buys a house, they are going to be given some sort of a deed, or as we call it, an acquisition instrument. It could be a deed, it could be by will, it could be, but they're going to get title to a property. Most clients you're going to represent, 99% of them, it's going to be on a deed, and there are different types of deeds. But in order for that, so what's going to happen is you go into settlement, the seller signs, the buyer, the lender gives the money, and the title company's handling all that, and the settlement company, and now the seller signs the deed, and it's notarized by the notary or the attorney, the title attorney, who's doing the settlement. Now, that by itself is not really evidence of ownership. There are a couple of things that need to happen before that deed is valid. Number one, a deed has to be delivered in order for it to be valid. So here's what that means. You go into the settlement company, the seller signs the deed, it's notarized, and now the attorney will hand deliver to the buyer sitting across from him, here's your deed. And some old-time attorneys still do that to this day, although not many anymore, but that is hand delivery. That's where the term a deed must be delivered comes from. But there are two ways to deliver a deed. One is you can deliver it by hand, and that constitutes notice. That constitutes a valid ownership of the property. Or the second way to deliver the deed, which is the most common way and most secure way, by the way, this is how we do business, is get it recorded in the land records. So the land records are simply where everybody goes to record documents, in our case, that affect real property. So if you borrow money against the property, guess what? There's going to be a document in the land records indicating so. And we'll talk about the two types. If you buy a property, well, the deed is going to be recorded in the land records. Anything that affects the property has a document recorded in the land records. And why do we record them? Why does everybody want to record that? Well, because if a deed is not recorded, it may be valid on its face because it was delivered by hand, but somebody else can come along and sell that house from under you. Why? Because there is no notice that it's recorded in the land records. And if it's an unrecorded deed, the title company won't know about it, and it creates hassles. So really, almost 100% of the time, a deed is recorded, and that constitutes what they call constructive notice. So constructive notice is telling the whole world that that property belongs to me. Actual notice is if a deed is simply delivered to the owner at that point. So that's the difference between the two. Let's continue. I know I'm giving you a lot of information, but Chapter 2, encumbrances. There are two types of encumbrances. Okay, an encumbrance is a general term for anything that affects the use of the property. So for example, if there's two types of encumbrances. One is money encumbrances, and the second is non-money encumbrances. Money encumbrances is an example of that would be a lien. A tax lien on the property is a money encumbrance. A deed of trust is a money encumbrance. Mechanic's lien is a money encumbrance. Those are also called liens. Okay. Non-money encumbrances, on the other hand, are things that are non-monetary, but they do affect the use of the property. So, for example, how does how does having owing money on the property affect the use of it? Well, you can't really sell it unless you pay the loan off. That's an encumbrance against the property. An IRS lien, well, that has to be paid off. That's a lien on the property. So money encumbrances are called liens, right? Non-money encumbrances are things like easements, things like, for example, you could have restrictions on the property. You could have HOA restrictions on the property, and those run with the property. So whoever has restrictions, for example, let's start with that. By the way, restrictions used to be very common, but not quite as much anymore, but they do still exist. So for example, I could sell a property to somebody and write a restriction myself that says no alcohol will be consumed on the property. Can I do that? Absolutely. If you don't like it, don't buy my property. But guess what? If you do drink alcohol, the property will revert back to me or my heirs. And that restriction will run with the property forever unless a court order or unless it's released by operation of law or otherwise by agreement. But if you put a restriction on the property, it's what's called an appurtenant restriction. It's going to run with the land. And if somebody doesn't like a restriction, don't buy the property. It's actually very common in Utah to have that. Well, not common, but there are some areas in Utah where they still have, alcohol restrictions on a property. You could have, there used to be other restrictions that are no longer acceptable because of fair housing and discrimination laws. You couldn't sell it to certain people, etc. Those, even though they're still recorded in the land records, they are not applicable here. So that's one example of non-money encumbrance, which is a deed restriction or a restriction or an HOA documents. Those are all restrictions, and those are classified as an encumbrance. Okay. The second type of non-money encumbrance, the common one, is an easement. The easement is an agreement between two people where one party gives the other the right to use some or all of their land. That's an easement. It's recorded within the land records. You could record it as a separate document, or it could be a deed easement. It goes with the land. If it goes with the land, that means that when it gets sold down the line, the easement comes with it. That's called an appurtenant easement. That's one type of easement. And you'll find that a lot in properties that share driveways. You have a flag lot, you have to go through somebody's driveway to get to your property. You're going to find a lot of easements there. Somebody wants to build something, and they're going to, if they don't get an easement, they're going to encroach on your land, so you give them an easement for the right to occupy that little piece. That's called an appurtenant easement. An easement in gross, however, is not specific to any one person. An easement in gross is given in the case of utilities. So when you have somebody coming to check your meter, well, that person wasn't given specifically to them. It was given to the power company, water company, and so on. So these are called easements in gross. Creating easements is really simple until you get to the third way of doing things. Express grant. And by the way, let's talk about a couple of terms here. The parties that have the easements are defined as the such, and you need to know this. The first party is called the dominant tenement, and the second party is called the servient tenement. So the servient tenement is the one giving the easement. The dominant tenement is the one getting the easement. Okay. And you only need to know that for the exam. After that, you're probably not going to need to know those terms. But it could be created by grant. So two people agree on it and put it in writing, and whether money exchange or not is irrelevant. Now you have an easement. The seller of a parcel who owns adjoining land reserves an easement right away over the former property. That's another thing that we talked about. A driveway, and you have an easement over that. In the United States, there is no such thing as landlocked parcels. Okay, you have to have some sort of way to get to your property, unless you own a helicopter, which is not allowed. So An easement by necessity is an easement where a parcel of land is landlocked, and you could actually go to court and sue to get a right to an easement if the person you're dealing with refuses to give it to you. And chances are it's going to get granted. Some sort of an agreement is going to have to come into play for landlocked parcels. But there are many things that go into that, but that's all you need to know for now. Easement by necessity. Easement by prescription. It is when somebody goes over, let's say that there's a pathway, it's a shortcut for a lot of people to walk to the store from their home. And they're always taking that shortcut, and they go through somebody's land. But, you know, that person keeps saying, don't walk through my land, and you keep doing it, you keep doing it. You put a no trespassing sign, people keep doing it. Well, after a while, the person who keeps walking on the land may have the right for an easement at that point. They can petition the court to get an easement to say, hey, there are certain requirements to get that. One of them is you have to be hostile to the true owner's wishes. Number two, the owner has to know that you're doing it. And number three, it has to be uninterrupted use. Okay? If that happens, you can get an easement by prescription, and every state has different lengths of time as to when the easement by prescription can be acquired. So easement by prescription is hostile to the owner, and that's why a lot of people, a lot of times if you go hunting or fishing or go in the wild, you'll see signs that says trespassing permitted. Why in the world would they say that? Well, because it takes out one of the elements of easement by prescription, meaning you're not hostile to the true owner wishes and they can't do it. Other times a city will block off a street or an alley or a walkway for one day. Why? To interrupt the use, and therefore nobody can get an easement by prescription. But those are the basically the ways to get an easement. Terminating an easement, number one is failure of purpose. Well, we thought we were going to need it, but we don't need it anymore, and it's done. Abandonment is the same thing, virtually the same thing. The need doesn't exist anymore. Okay, I no longer need to go through that land because I bought the parcel next door and I could use that instead. Merger, if I buy the property next door to me that I had an easement on, well, I don't need an easement to go on my own property, therefore it terminates it. Express release is when the dominant tenement is the only one who could release an easement, meaning the person who has the right to use that easement, the dominant tenement, they're the only ones that can say, you know what, I don't need it anymore. Here's your easement back, I'll record a release. That's agreement by the parties. So those are the ways to terminate an easement. Will, a couple of things you need to know about wills. Wills obviously are used to dispose of property, transfer title to real property after somebody's dead, and a couple of things. A will is known as a living document as long as the person is alive. Pay attention to that. A will is known as a living document as long as the person who made the will is alive. All right. Second thing you need to know about wills. If somebody dies without a will, they are said to be, they passed away intestate. Intestate. They died without a will. Number three, if somebody has a will that's handwritten, that's all it was, handwritten on a napkin or a piece of paper, that is called a holographic will. You may get questions on that. It comes up very often. Holographic will. A famous example of a holographic will was Howard Hughes. He died, and even with all his wealth, left a holographic will handwritten. And I think up until the 90s, they were still trying to figure out who owns what and who gets what. So the other thing you need to know about a will is there's going to be a person named to handle the distribution of assets. That person is known as an executor if they're male, executrix if they're a female. You'll hear the term executor all the time, and they refer to male and female. But on the test, you need to know the difference between the two. Executor or executrix. Executrix for a female, executor is for a male. All right. Sometimes you have title, you have land added to your land, added or taken away by natural forces. So, for example, if you have an erosion, okay, gradual wearing away by land. Let's say that the water keeps coming closer and closer and closer on your land, and all of a sudden it's flooded. Well, that land is gone. You know, that's erosion. Accession is an addition to the property by man or natural forces. Let's say that the water goes away. Now you've gained all kinds of land, subject to certain restrictions. But accession is when you gain. The erosion is when you lose land. So that's one way to acquire or lose additional or your real property. Adverse possession is very similar to easement by prescription. But instead of getting an easement, you're actually getting title to the property. Title to the property. So, for example, if you go hunting on and occupy this cabin in the mountains that's abandoned, you have to pay your taxes, you have to have the uninterrupted use, and you have to be hostile to the true owner's wishes. And if you do all that, every state has a certain amount of time where after that time, you can petition the court to acquire title by adverse possession. It's difficult to prove. It doesn't happen really in real life all that often, but it is something that's possible, and you need to know it for the exam. That's why we bring it up. Adverse possession is when somebody occupies a property that's not theirs, they pay the taxes on it, uninterrupted use, and openly, everybody knows that they're there, the neighbors see you, and the owner knows about it, does nothing. Now you have a right to, some states it's 5 years, some states it's 10 years. So as long as you meet the requirements, the court will grant title under adverse possession laws. All right, transfer by deed. There are different types of deeds, and we're going to talk about that, but let's talk a little bit about what a deed is and what it does. A deed is simply a document, a written document between two people, where title, evidence of title, that's the deed, is conveyed from one party to the next, period. Written document in which one party transfers title to another party. That's a deed. So it's a very simple explanation. But there are certain elements to a valid deed. You can't just have a deed, you know, willy-nilly. It has to meet certain requirements. Legally competent grantor. All right, so once in a while in our business, you might meet a seller who you think may not be all there, okay? Either they're elderly, maybe they're intoxicated, in which case I've had to delay settlements because the buyers or sellers showed up intoxicated. Well, that's not legally competent at that moment, and that could be challenged later. You don't want that. So legally competent. And the way that it works, unless you've been declared legally incompetent by a court, generally speaking, you are legally competent. Legal description. It has to have a legal description. An address is not good enough. A parcel number is not good enough. You don't convey those. Every property in America has a unique identifier, and that is called a legal description. You cannot have two properties with the same legal description. It's going to differ in one way or another. It could be a unit number, it could be a lot number, it could be a block number, but it's going to differ in one way or another. So it has to be legal competency. You have to have legal description. Because what would happen if you put 123 Main Street on there? How many 123 Main Streets are there? So it's not good enough. Consideration. Consideration can come in two forms. You can give some money. In our business, it's mostly money, but it could be anything. It could be somebody agrees not to do something or to do something, but you got to give something of value to somebody else. The other way to do consideration is what's called, you ready for this? Love and affection. Love and affection. You could actually grant somebody a deed. You can grant somebody title via a deed, and the consideration would be considered, no pun intended, love and affection. A deed has to name the grantee. Who's getting this deed? who's getting the property. So it has to have a valid, identifiable grantee on there. It has to be signed by the grantor and accepted by the grantee. Don't let them fool you on the exam, because this is very common. They'll put in there, it must be signed by the grantor and the grantee. The grantor is the seller, the grantee is the buyer. No, a deed doesn't have to be signed by the buyer. It only needs to be signed by the seller. So this gets into the legal competency. In America, you're legally competent unless you are declared incompetent by a court of competent jurisdiction. You have to be 18 years old to be legally competent. Or if you're under 18, you could be married. If you're married and under 18, you could legally contract. If you are divorced under 18, you could legally contract. So they're telling me that a married and divorced person under 18 is smarter than somebody who is, not married or divorced under the age of 18, but be that as it may. Anybody in the armed forces under 18 can legally contract in most cases in America. Those are called emancipated minors. Emancipated minors. So remember that. Emancipated minors are under 18, but based on these elements, they qualify to contract because they meet one of those requirements that we just went over. Legal description is, there are many ways to have legal description. Three common ones. One is metes and bounds, okay, which is a lot of times it could have a half a page, 1 page. I used to run metes and bounds that are 2-3 pages. It took me forever to learn it, but that's one way to do it. And, beginning at the point at beginning, POB is what they call it. Remember that when you hear the point at beginning, it's related to metes and bounds. Consideration, we went over that. Words of conveyance. A deed must have what they call operative words of conveyance. An example of that would be hereby grants to, hereby transfers to. Those are called operative words of conveyance, and it must have that. We talked about the grantor. Let's talk a little bit about the different types of deeds. General warranty deed. That is the highest degree of security that a buyer can get. Because, and I'm going to be sending you all this, by the way. Everybody on this call, make sure that we have your email address. That way we could send you the materials. I have a lot of materials for you. I have sample exams with the answers, etc. But please make sure we have your email on there. So there are covenants against encumbrances. I don't owe anything on it except what I disclosed. Covenant of quiet enjoyment. You're going to be able to enjoy this property. Nobody's going to bug you on it. There's no claim against it. And so on and so forth. You could read that. A special warranty deed, on the other hand, has less assurances from the seller. A special warranty deed is one that is used by lenders who foreclose on a property. And all they're going to say in a special warranty deed is, during the time I owned it, I don't guarantee anything before I owned it, but I will guarantee it for the time that I owned it. That's a special warranty deed. Whereas a general warranty deed says I'll guarantee title before I owned it, up to now, and sometimes in the future as well. Nobody's going to come and claim title to it. And if so, you could sue me. Title insurance policies really take that away. We don't see a whole lot special warranty, general, but it's still out there. Grant deed is the most common type of deed that you see in settlements, in a lot of cases, depending on your state. But a granting clause we talked about, and it has certain 2 implied warranties. In a grant deed, the seller says, I swear I did not convey title to anybody else, only you. Number 2, I swear the property has no liens except what I disclosed to you. Again, title insurance will take care of all that, but you still need to know it for the exam. Quitclaim deed is one of those documents that is the least favorable. All the quitclaim deed says is, I'm going to sign a quitclaim deed on this property from me to you. Oftentimes used for spouses, divorce cases. But what it says is, I don't even know if I have any interest in the property, but just in case I do, here's a quitclaim deed, period. No warranties whatsoever. So just make sure that you know quitclaim deed is the least favorable when it comes to warranties. A general warranty deed is the highest degree of ownership. Quiet title action, let me go through that. That's when somebody goes to court and there's some sort of what they call a cloud on the title. That's a legal term, cloud on the title. It's messed up. We don't know who owns it. People are making claims. It goes to court. Judge looks at it, makes a decision, and the judge will issue what's called a quiet title action. And the judge will decide who gets what and who owns it. So those two terms you need to be familiar with: cloud on title and quiet title action. Partition is when two people own property. Let's say they own it tenants in common, and there's a dispute of who owns what or how much or what have you. They can actually go to court, and the judge will decide who owns what percentage of it. They ask for what's called a partition action. And again, with tenancy in common, you could sell it, you could will it, you could do all sorts of things, but that's another action that could be taken. Escheat is when you have a state, or when you have a property. Let's say that the property taxes are owed, for example, and they're not paid, and they have 5 years. The property will then escheat to the state. If you hold an escrow account, if you're an escrow account holder, and there's money in the escrow account after a certain amount of time, if nobody claims it, it escheats to the state. It goes to the state. And that's why they need you to know that. Eminent domain is when the government comes in and says, you know what, we're going to take part of your front yard because we're going to put a road here. And they have to pay you reasonable compensation. You have to be compensated, but they can take it by law. They can take you to court. In most cases, and I've handled some of these, in most cases, people do it. They get paid off, and they'll give them part of it. If they don't, they'll go to court, and chances are they'll win. 90% chance they'll win. Condemnation. So eminent domain is the law that allows them to do it. Condemnation is the act itself. The act of taking the property is called condemnation. All right. Contracts. Different types of contracts. First of all, in our world, in the world of real estate, if it's not in writing, it isn't. It never happened. So if you remember that, you'll do well on all these different types of contracts. I want to, out of those here, I want to do this. I want to cover unilateral and bilateral. Unilateral contract is one side promises to do something, and the other side is not obligated to do it. So, for example, I'm thinking about buying a property. I'm leasing it now. So I give the owner $10,000 to buy the option to purchase for 3 years. What that means is the owner is not allowed to sell the property for 3 years. So the owner is obligated to do something. I don't have to buy it at that point. So that's a unilateral contract where one party is obligated to perform and the other party is not. Bilaterals, when two or more people make the decision together. That's the difference between the two. Parole evidence is, parole means that it's verbal. There is no such thing in our business except for leases that are 1 year or less. Okay, 1 year or less. So that's one thing you have to keep in mind. So different statuses for a contract depending on what stage of the transaction or what's happening. Avoidable contract is, on its face, it may be rejected, but the parties still continue to be in the transaction. For example, you have a contingency on the offer that says the settlement is going to take place on October 29th. October 29th has come and gone. Well, technically, that contract could be voidable, meaning it could be voided. However, the parties choose to stay in there. A void contract is simply that has no legal effect. A void contract could be a minor signing the contract, somebody who's not of legal or mental capacity. All these things is unenforceable. A verbal contract is an unenforceable contract in real estate. Valid contract is binding and enforceable on everybody. Statute of frauds, and by the way, that comes from the English common law. And in a nutshell, certain contracts have to have, they have to be in writing. So for example, real estate, that has to be in writing. And it's all up to you, I mean, it's all up to the state to determine what contracts have to be in writing in order for them to be valid. But the statute of frauds, it's an old rule. It came from England. They adopted it in 1677 under the English common law, and we still use that today, as most of our laws, like I said earlier, from the English common law. Contracts must be in writing. How do you extinguish a contract? How do you terminate a contract? One is full performance. Buyer gives the money to seller, seller gives the deed, we're done, settlement takes place, contract is done. Released by one or all parties. One party can pull out of a contract, that contract will be terminated. Doesn't matter whether the other party can sue or not, but the contract is terminated. Sure, if the other party is allowed to sue, they could do that, but the contract itself is terminated. Assignment, what we call now, let's say that what we call now wholesaling. Have you guys heard that term recently? Wholesaling. Somebody buys a property, somebody puts an offer on a property, and in the offer it says, I'm allowed to sell this offer to somebody else. So they'll put in an offer on a property and sell it to somebody else and make a little bit of money on that. The sale of that is called an assignment of a contract. Or if you loan somebody money and you hold a note, you loan somebody $10,000 and you get a note on their home, and you don't want to wait 10 years to get your money, so you sell that, it's discount it and sell it in the secondary market to somebody, and there's a big market for that, by the way. You sell it at a discount. So maybe instead of $10,000, they'll give you $8,500 cash, and they will collect the money for the next 10 years. But you do that by virtue of an assignment of a contract. Novation is when you take yourself out of it and you put somebody else. For example, if somebody has a loan on the property and the loan is assumable, the seller is responsible for that loan. A buyer comes in and says, I want to assume your loan. Well, if you don't do the act of novation, the seller will still be responsible for that loan. However, there's a process they go through. You do that in VA a lot. It's called a novation, where the seller is out, the new buyer is in, seller is absolved of any responsibility. Now the buyer is in charge of it. Breach of contract, we talked about that earlier as well. You can mutually terminate a contract, as we discussed, or you could, one party can get out of it, and again, the other party could sue. Let's see, I am going to move on. Agency. Agency is basically, it's a written contract. It has to be in writing in most states now. And if you're a member of NAR, which all of us are, I would assume, or will be, it has to be in writing. Agency is one person representing another person in a particular matter or matters. That's agency. So if somebody comes to you, a buyer says, I want to buy a property, fantastic, let's create an agency. I want to sell my property, great, let's create the agency. Keep in mind that the agency is not created with the agent. The agency is created with whom? The broker, okay? It's always the broker. So everything belongs to the broker. So the agency, you have two parties, a principal, you have to know that, a principal, that's the person that you're going to be serving, and the broker, okay, the agent. And it's what they call a fiduciary responsibility. Fiduciary means that you're bound by agency laws in your state, and you have to work in the best interest of your clients. Every state has laws regarding agency, which means you have to do certain things at certain times, treat the client a certain way. Some states are more than others. They legally define what agency means. So the agent has to, and when I say agent, it's really the broker. The agent has to accept the authority. And the delegation of authority, there's a couple of ways to do that. You could represent a principal in one transaction, or you can create an agency where you represent the principal in multiple transactions, or you can have an agent that binds the principal. We don't get that very often in our business, which means that whatever the agent decides to do, let's say the agent is permitted to sign contracts on the principal's behalf, well, that's binding. Most of the agencies we get are non-binding. Let's talk a little bit about the types of agencies. Single agency broker, that means that you're going to represent either the buyer or the seller, not both. Dual agency is when you present both. And of course, there are disclosures that have to be made at that point. Buyer agency is when you represent the buyer. Designated broker. So if you have two people in the same office, one agent has the listing and the other agent brings in the buyer, but they're still under the same broker, same company, this is called, the broker is called a designated broker at that point. It's not really dual because one agent is not representing both, but the broker is dual to both of them, but the agents are called designation at that point, designated agents. Transactional broker is not really an agent. It's not really a, it's a non-agency document. Those are the folks that put the property in the MLS and they do nothing. That's a transactional broker. So they're not bound by a lot of the things that we're bound by when it comes to agency relationship. Types of listings. Exclusive right to sell listing. There's a huge difference between the types of listings, and you need to know that. Number one, exclusive right to sell. That means that I am the seller, I'm giving you the listing, and what I'm saying is, I don't care who sells the property, I'm going to pay you. Even if I sell it myself, I'm still going to pay you whatever we agreed to. Exclusive agency, the seller says, I will pay you if you or anybody else sells the property, but if I sell it myself, I won't pay you. So that's the one thing. So make sure you pick the right agreement when you do this, and make sure you know the distinction on the exam because it should come up. Open listing. That's when I don't have a particular broker in mind and I say, I'll pay anybody who can bring me a buyer. Think of a for sale by owner, for example, but they'll give everybody an open listing. If you bring me a buyer, I'll pay you. And that means whoever brings in the buyer will get paid. Net listings are not allowed in most states, in fact, all states, but it still comes up on the exam because they want you to know what you can't do. A net listing says, I'm going to list your house for $100,000, and anything above $100,000, I'm going to keep. That'll be my commission. And you can see where the trouble can come in there. So it's not allowed, and none of the states I know have net listings, but you need to know the definition. Let's continue. Contracts. Contracts to sell or purchase. Number one is it has to be in writing. Let's say that you're the buyer agent. You're representing the buyer. You put together an offer to purchase real property. Okay. You have all the terms in there. You send it to the seller. The seller has three options at that point. They could accept the offer as is. They could reject the offer, or they could counter the offer, meaning that I'll accept most terms, but I don't like this and I don't like that. Okay, I'm not giving you $5,000 in subsidies. So that's a counter offer. So you have offer, counter offer. When the counter offer is made and delivered to the buyer at that point, guess what? It's a brand new offer. The buyer's not the buyer's not obligated to follow the initial offer. So anything you change and anytime you have a counter offer, it basically invalidates the entire offer. It becomes a counter offer. A lot of agents get confused about this and they think, well, everything is good except that, so let's counter with that. And next thing you know, the buyer's pulling out and the seller says, I'm going to sue you. No, you can't. Okay, so anytime there's a counter offer, that you basically start brand new. Simultaneous offers could be presented. That's the market we've been in. Tons of offers could come in. Revisionary right, that's the right of the landlord to reclaim the property at the end of the lease. That's a term you need to be familiar with. Let's see. Option, we talked about option. You could tie up a property because you are thinking of buying it, but you're not really obligated, but you pay for it, or you don't have to, but usually there's a payment involved that says, don't sell this property for 3 years because I might want to buy it. At the end of 3 years, they say, okay, well, we don't want it. Everybody wants it. Leases, types of leases. Leases are bilateral. Remember, unilateral, uni, Latin, one. Bilateral, two. So leases are bilateral, and there are different types of leases that we know. First of all, there's a gross lease. And that's a type of lease that it's also flat, fixed, or straight lease. Remember the terms flat, fixed, or straight, they associate with gross because they will use that interchangeably. The tenant pays the rent payment, and everything else is paid by the landlord. That's a gross lease. A net lease is the tenant will pay a certain amount of payments plus they'll also be paying certain items like taxes, insurance, repairs. The net lease, sometimes you hear the term triple net. It'll cover 3 items on there. So net lease is when the tenant pays the rent, plus they'll be responsible for maintenance, taxes, insurance, etc. A percentage lease is when the tenant says, when the landlord says, okay, you can pay me $5,000 a month, and I want 5% of your gross receipts. So they participate in the profits of that lease. You don't see that much on residential properties. You'll see it on commercial properties, and usually with big chain names. That's how they do that. You get a percentage lease of the gross receipts. Sublease. Sublease is when you are permitted, the lease has to approve, there has to be provide that it can do that. But it's when you have a lease and you yourself want to sublease that part of your estate to somebody else. For example, you rent a space that has 10 offices in it. Okay, you're the lessee. Now you have that right to occupy 10 offices. You realize I really don't need 10, I only need 5. So you find another person to come in and lease those 5 from you, not from the landlord, from you. That's called a sublease. The person who comes in is called a sublessee. A sublessee is a person who comes in. They're also known, you got to remember this term, a sandwich lease. Okay, that's a sandwich lease. So they'll use those terms interchangeably on the exam. How do you terminate a lease? Very similar to a contract: expiration of the term, mutual agreement. Violations: you're not allowed to have more than 3 people living here, but you have 8. Well, they can terminate the lease. Or if the property goes up in flames, there's nothing to lease there. Eviction: certainly the landlord has the right to do that, and if somebody's not paying, different states have different laws about that. Disclosures. So disclosure of agency relationship, we talked a little bit about that, but let's talk about disclosures of the property itself. A couple of things you need to know. We don't need to read the whole thing, but when it comes to property disclosures, certain states have certain requirements. There are certain forms that you have to fill out, certain things you have to disclose. But generally speaking, that anything that you know about that is what's called a material fact, that's what they call it, anything that would affect the use or the enjoyment of the property that you know about has to be disclosed. And a lot of people think, well, if I sell it as is, I don't have to tell. Yes, you do. You have to tell them what as is. So if you know that the basement leaks consistently, and every time it rains, it does, it's not rain season, and you don't disclose that to the buyer, well, that's a problem. That is a material fact. A material fact is defined as anything that will likely influence the decision to purchase. That's a material fact. So had I known that your roof leaks, then I probably wouldn't have paid you as much, or I would not have bought the property. That's a material fact when that happens. So that has to be disclosed. Certain states, like I said, have their own forms, and you have to disclose, or say, I don't know. I don't have any knowledge that the roof leaks or anything like that. And they go through a whole bunch of, things that could be wrong with the property, and they either say yeah or nay. Material fact, latent defect. Latent defect is a defect that's not known to the buyer. They can't really see it, but the seller knows about it. So, for example, you have a carpet, okay, in the living room, and the settlement takes place, but they flip up the carpet, and there is like concrete underneath it. You were expecting hardwood floors, like the perimeter around it. Well, that's a defect that should have been disclosed. That's actually a violation that's a breach on many levels, but that's one area. That's what a latent defect is. Or that the back of the dishwasher leaks and it's not really visible, and the property inspections really do all that, and they give the buyer a little bit of comfort, but still it has to be disclosed. If you're in a flood zone, how do you know you're a flood zone? You check the FEMA maps. That has to be disclosed. You've got the lead-based, environmental. So you're going to get this a lot of times, the asbestos in some older properties. Radon, when you have a lot of rocks, if the lots are very rocky, you might have radon, and you might have to do a radon inspection. That has to be disclosed if it's high, if the seller knows. Lead is a federal disclosure, and the fine for that is a lot of money, by the way, a lot of money. I think last I checked it was 10 grand per occurrence, but I think it's more than that now. The seller must disclose if there's lead-based paints in the property. And the cutoff date for that, by the way, is 1978. So if a property was built prior to 1978, like 1977, the lead disclosure must be there. If it's built after that, it does not have to be there. And that goes for rentals too, by the way. Okay, that comes up every now and then. The lead and rental, for whatever reason, a lot of agents don't think that it does apply to rentals, but it does. Underground tanks, if there's an underground tank, you need to disclose it. Stigmatized property, that's one of my favorites. Stigmatized property is one of those properties that, remember when you were a kid, there's always one house in the neighborhood that was set to be haunted, and as a kid, you always walk around it because you think it's haunted and a monster is going to come out and reach for you. That's a stigmatized property. The seller goes to sell, oh yeah, it's that haunted house. It's psychologically impacted by an event, a murder that took place. Okay, those are things that would be good to disclose, but they won't really. You haven't seen a lot of court cases where a stigmatized property gets the owner or the seller loses that. But it's good to disclose it. In fact, some states have ghost rules, meaning that if a property is rumored to be haunted, you have to disclose that. Okay, I don't know if your state is one of them, but there are some states that have haunting laws, as they're called. All right. RESPA, the Real Estate Settlement Procedures Act, is an act that was passed in 1974, and it provides certain protections to the consumers. And in financing, one of the things that falls in that is a Truth in Lending Act, and sometimes known under Regulation Z. And with the Truth in Lending Act, the Reg Z is triggering terms like down payment, number of payments or terms, the amount of the payment, the finance charge. Those terms have changed over the years, but they all do the same thing. The lender has to disclose all the terms that listed above here, the finance charge. So for example, before closing, the buyer will get a statement that says, oh, you're borrowing $500,000, but by the time you pay it off with the interest and all that, you would have paid $1 million to us. And I'm just pulling numbers out of the air. It may not be that much, but depending on the interest rate, etc. But that's one thing that we have to be aware of for the exam, that it's part of the disclosure in financing. So RESPA, on the other hand, is an act that was passed in 1974, like I said, and it applies to our industry in that it prohibits kickbacks. So I can't go to, for example, a title company wants my business, and now they're going to give me $100 for every person I refer to them. Unless you have a protocol affiliated business arrangement, ABA, there are proper and legal ways to do that. It falls under Section A of RESPA. But if it's not done legally, if it's not done in a way that is that is by an attorney, basically it has to be done, that would be a violation of RESPA. And it used to be willy-nilly. RESPA was hardly ever enforced in the years I've been in, but the last 15 years or so, they've been coming down hard on anybody who violates RESPA rules. What they'll do is they'll come in and they'll target a city, and they'll come in and make headlines, and they'll get some real prominent people and hit them with fines and jail. Yes, jail. And to make an example of them, and they'll move on to a different city, and they'll come back a few years later. So just be aware that RESPA 1974, and it prohibits undisclosed rebates or kickbacks, or prohibits fee splitting and anything of the like. Equal credit opportunity protects some folks from discrimination, color, race, religion, and the things you see there. The one that is somewhat new is persons receiving income from public assistance. They don't want lenders to discriminate against people who receive public assistance, either Section 8 housing, et cetera, et cetera. Not so much Section 8, but subsidized payments that they get. It doesn't matter where the payments come from, as long as they qualify for the lease or the purchase of the property. Doesn't matter where the money's coming from. The lender has to make the decision based on that, not where the money comes from in this particular case. But this affects the lender, and the lenders have to abide by that. When they don't, there's going to be major consequences, because any kind of discrimination is bad, really, really bad. HUD makes it really bad. Other governing authorities make it really bad for the people who commit violations when it comes to fair housing in general. Escrow and closing. Escrow is a term that is used usually on the West Coast, meaning there's an independent third party that's going to handle all the paperwork and administer the closing. On the East Coast, they call it a settlement. Okay, settlement companies, escrow companies, but you need to know both for the national exam. They do the same thing virtually. It's a third disinterested party. So a settlement company, by the way, if you go to a settlement attorney, for example, on a transaction, the settlement attorney does not represent the buyer. The settlement attorney does not represent the seller. The settlement attorney represents the contract. That's their job. They're supposed to be neutral. They're not supposed to be giving out legal advice to either party. We know that happens. I do know that happens, especially the buyers, since the buyers are bringing the business to them. But just remember that under the escrow rules and settlement rules, a closing attorney or a closing agent may not be partial to one side or the other. They represent the contract itself. Title. All right, remember that title that you get a deed for the property. What is a deed? A deed is evidence of title. Okay? A deed is evidence that you hold title to that property. Now, when you buy a property, don't you want to make sure that the owner really owns it? You want to make sure that the owner only owes that one loan on it and not hiding anything else. You want to make sure that nobody's going to come from somewhere and claim title, that they have interest in the land. There's a lot of things that you want to make sure of when you're buying this property. And the protections you get from the general warranty deeds are well and good, but good luck in court. It costs so much money. So back in mid 1800s, title insurance was born during that time. And title insurance basically says, you pay me a fee, and I'm going to guarantee you, Mr. Owner, that your title is good, your title is free from any encumbrances except what we tell you, and there's all sorts of things that a title policy covers. It has evolved over the years. Owner's policy was greatly revised in 1996 with a company called First American Title. They came up with the first type of policy that's what we use now. It's sort of a standard called the Eagle policy, and every title underwriter has their version of it, but that covers a lot of things. The difference between title insurance and other types of insurance: title insurance covers things, for the most part, that happen prior to insurance date. Okay, anything prior to the title policy. Medical insurance covers things that are going to happen after the policy date. Life insurance after the policy date. So that's a big difference between the two. Although title does have some policies cover future, but let's not get into that now. There are basically a couple of types of policies, few types of policies. The most common one now is called an enhanced policy. Enhanced policy. And that gives the most comprehensive coverage to your buyers. Please make sure your buyers buy that. Okay? Please make sure they buy title insurance, period. But that's up to them. Our job is to advise them to get title insurance. It's not to make sure they do it. So that's an owner's policy, and it's also called an enhanced policy. There's another type of owner's policy which is hardly issued. That used to be the default prior to 96. There's a lender policy. Now the lender says, yeah, I'm going to loan you some money, but you know what? I want protections too. Because if somebody comes in and says, yeah, I own the property, well, that's all well and good for the owner, but what about me? I'm investing a lot of money in this property. So the title company will issue what's called a lender's policy. And that protects the lender from similar things as the owner. Another term you need to be familiar with is what's called a title commitment. What is a title commitment? It's before the policy, before the insurance takes place. They're going to send out someone to the land records or access them online, and they're going to get what's called an abstract of title. They're going to research title and see what documents are recorded in the land records that affect title to the property. They're going to put it all in one report, and the attorney's going to take that, and they are going to issue a title commitment. And a title commitment basically is what it sounds like. I commit to insuring this property at closing, except for these things here. And they'll list a whole bunch of stuff. There's Schedule A, Schedule B exceptions. You don't need to know all that, but that's what a title commitment is. You need to know this for the exam. It's also known as a title binder. Binder and commitment mean the same thing. Don't forget, legal description is required on deeds, on really most documents that are recorded, because an address is not good enough. They're certainly required. The lender insures the property via legal description. Whatever's on that legal description that's what's insured. So if the lender missed a lot, or they forgot a parking space that goes with it, they forgot an easement, they're on the hook for it. So that's why legal description is so important, but they handle that for us. Tax benefits, be very careful here. We're not tax advisors, but a couple of things you need to know. There's something called FIRPTA. It's a law that was passed a while back, Foreign Investment in Real Property Tax. And what basically it says, if the seller is a foreign person, meaning they're not a permanent resident, nor are they a citizen of the United States, a certain amount of money has to be withheld from their proceeds. So the escrow company, the settlement company, has to hold that by law, and it's 15%. Okay, 15%. That's not something you need to worry about. It used to be that it was the responsibility was on the agents when it first came out, and they fixed that. But there are some exceptions to that. Number one is if the sale is $300,000 or less, which covers a lot of areas, and the property will be used as a primary residence by the buyer, then there's no FIRPTA. Okay, there's no money involved. But if the sale is between 300 and $1 million, but it'll be used by the buyer as a residence, for primary residence, by the way, then the rate goes down to 10% from 15. So 300,000 and below, nothing. 300,000 to $1 million is 15. And yeah, again, that's something that the title attorney needs to handle, and they do handle it, but you need to know about it for the exam that you have coming up. Tax benefits, some deductions, deductible expenses that you need to know for the exam. Interest, property taxes, non-deductible expenses, maintenance, depreciation, and capital improvements. Each one of these categories, they may have to have a tax person, a CPA, not a CPA, but a general accountant can do all this, but you just need to know the titles of these. We could spend a half hour on each one of these to explain them, but interest, property taxes, non-deductible expenses could be written off, maintenance, depreciation, and capital improvements. Capital improvements are any improvements that you've done to the land. Those are capital improvements, and that's how that works. The other thing that you need to know about taxes is that when somebody, capital gains have changed over the years, and they're talking about changing it again, but generally speaking, a single person who sells a property, it has to be a primary residence. How do you define a primary residence? They had to have lived there 2 of the last 5 years. 2 of the last 5 years. If they qualify for that, an individual can write off the first $250,000 of profit is tax-free. If it's a married couple, the first $500,000 of profit is tax-free. So anything above that, they'll have to pay capital gains tax on. If they qualify for the exemptions, and then that's what they get, fantastic. Then they qualify for that. Corporations. A C corporation is, when it comes to doing business, it's one of the few entities that gets taxed twice. So when the corporation itself makes money, the IRS is going to tax the corporation. They have to pay corporate taxes. And when dividends are made to the members of the corporation, the members have to pay taxes on that money. So it's a double tax on C corporations. S corporation is a little different, but it does have the tax advantage. And they're usually taxed and only once at the shareholder level. So there is no corporate tax on S corporation. So just remember the difference between the two. C is double, S is single. There's only it's only at the shareholder level. Just remember, S is for shareholder. Okay. Finance, promissory note. Promissory note is the evidence of debt. That's what a promissory note is. It's an IOU. That's what it is, IOU. And it becomes a negotiable instrument. Well, what's a negotiable instrument? Negotiable instrument we talked about earlier is when, let's say, a lender made a $100,000 loan. They don't want to wait 30 years, and most lenders don't. They don't want to wait 30 years to get the money. So what they do is they sell it in the secondary market, and they'll get a little bit of money on it, discounted. It's also called a discount. And the entity that bought it is going to wait the 30 years to get the money. The money's really made. Yes, money. There's money in interest. There's money in points. There's money in origination, but the real money is made on the servicing of the loan. All those people that send out the bills, they collect the money, they send out the taxes, the insurance, they get late fees. That's where the real money is made over the life of the loan. And it's not uncommon for a loan promissory note to be sold several times throughout the term of the loan until it's paid off. You have all these types of interest. You have the interest rates, prime rate. That's what the Fed charges commercial banks. I'm sorry, the prime rate is what charged by commercial banks to their most credit-worthy customers. That's the prime rate. It's a good rate. Discounted rate is what the Fed gives to the member banks. And there are two ways to repay. There are two ways to, actually several ways to pay back the money. A loan that's considered interest only simply means that you start out with $100,000 and you're making a $1,100 payment per month, and that entire $1,100 is interest only. So by the time the loan 30 years from now, how much do you owe? $100,000. Okay. Typically, that's not how it works, but that's the example that I use. Interest only, you still owe the entire principal. The second way is amortization, which means that every payment you make, a portion of that payment is going to go to the principal. In the very beginning of the loan, it's very, very tiny amounts that go to the principal. But as the years go on, you could, the more and more principal money will go to the principal than it does for the interest. You could always make more if your loan permits it, and most loans now permit it. You can also write if your payment is $1,100 and you pay $1,500 and you say apply $400 to the principal, well, all of that will go to the principal. But that's amortization, where it's fully amortized. In some cases, it's partially amortized. ARMs are the adjustable rate mortgages. We don't see too many of them nowadays, only because the interest rates have been very low. But ARMs are the type of loans that will start at a very low rate. It's called the qualifying rate. So let's say that the current interest rate is 6% and the qualifying rate is 4.5%. So the buyer that's coming in doesn't have to qualify at 6; they qualify at 4.5, right? Which gives them an opportunity. And that term will be fixed for a certain number of years. So, for example, the qualifying rate 4.5%, it will be fixed for 5 years, 10 years. Some of them are 15 years. Some of them are a year. It really depends on the loan itself and the terms, but that's the qualifying rate. Adjustable rate mortgages go up and down. They go up and down according to what we call the index. And the index this is what it's tied to. For example, and I'm just going to pick something out of the air. An index could be the T-bills. Okay? So a loan, when they go to adjust the interest rates, they're going to go look at the T-bills, what the interest rate of the T-bills has been for the last however long, and they will add a certain percentage to it called the margin, which is fixed for the life of the loan, and that'll be the new interest rate. So the interest rate could go up or it could go down depending on the economy. So if the T-bills are high and paying high interest rates, well, the borrower is going to pay high interest rates. If it's low, then it gets lower. And this is a very, very simplistic view of ARMs, but that's really all you need to know for now. All ARMs are tied to an index of some sort. The lender has what's called a spread, a margin, and that's what you add to the index to come up with the final interest rate. So the interest rate could be 5%, but for the T-bills, and the lender says, no matter where the T-bill is, I'm going to make an additional 2%. So the interest rate now is 7% when they adjust it, you see. So that's a spread, or the margin, as it's called. Now, there are certain protections that are offered to the buyer. One of them is there's a payment cap, which means that no matter where the interest rates go, your payment will not go above a certain amount per month. That's a protection. There are a couple of things we need to watch out for, like negative amortization and so on, but we won't get into that. But that's a protection offered to the buyer. A lifetime cap means that, okay, here's the interest rate. It's going to be up and down, but no matter what happens to the interest rate, if the market goes crazy, your interest rates will never be over 10% for the life of the loan. That's a lifetime cap. Payment cap, and there's also an annual cap. That's the periodic, I guess. An annual cap, it says your interest rates cannot go up more than 2% per year, per 2 years, per 5, per adjustment period. Those are the caps that they offer their borrowers. When you go buy a piece of property and you are borrowing money, I know the term that we use a lot is mortgage, mortgage, mortgage. But the reality is we don't have mortgages here on the East Coast, at least in our states. I don't know what state you're from, but for the most part, we don't have mortgages. We have what's called a deed of trust. The difference between the two, a mortgage is a contract between two people, mortgagor or mortgagee, the borrower and the seller. I mean, the borrower and the lender. That's it. Deed of trust has 3 parties to it. Okay, you have the trustor, who's the borrower. You have the beneficiary, who's the lender, and you have this third party called the trustee. Okay, those are the 3 parties to the deed of trust, and you need to know them: trustor, trustee, and beneficiary. The trustee, we know who the borrower is, we know who the lender is. The trustee is only allowed to do 2 things throughout the life of the loan. Number 1, if the loan's paid off, the trustee will record a certificate of satisfaction or a release, depending on your state, and it tells the world that the borrower paid off the loan. That's the first responsibility of a trustee. The second responsibility of a trustee is they start foreclosure action. If the lender tells them that the borrower is now in foreclosure, they start the foreclosure, they take it all the way, and they sell it at the courthouse steps via a document called trustee's sale. Okay, trustee's deed, I should say, at an auction. So that's the difference between a deed of trust and a mortgage. Mortgage is a contract. The deed of trust is actually a deed. They convey what's called the legal naked title to the trustee. Okay, legal naked title. I didn't make that up. That's a legal term they use for it. And that's what the trustee holds when it comes to that. Another type of way to finance a property is acquire interest in the property is contract for deed. And it basically says this: I want to buy your property, but I can't afford it now. But let me pay you as I go along. Let's record a contract that says I'll pay you, I'll make payments for a certain amount of time. A percentage of those payments will go towards the down payment. 2, 3, 5 years from now, I'll buy it and you give me a deed. Contract for deed. Contract for deed. So believe it or the parties for a contract for deed you need to know are the seller at that point is called the vendor. The buyer is called the vendee for a contract for deed. Vendor-vendee relationship. And the contract is recorded in the land records. Why? So everybody in the world will know that the property is tied up and the seller can't do the same thing to others. The property is to protect the buyers at that point. So vendor-vendee, contract for deed. There's so much that goes into that, but for now, that's what we need to know. Default and foreclosure. There are 2 ways to foreclose on a piece of property. One is judicial foreclosure, one is non-judicial foreclosure. actually three ways. State of Maryland has what's called a quasi-judicial, but let's just stick to judicial versus non-judicial. Judicial foreclosure is when usually done on some mortgages, but it's when somebody takes somebody to court. The lender will take the borrower to court, and they'll foreclose that way. The court will decide if they're in default or not, and the court will decide all the ins and outs, how much they owe, et cetera, et cetera. That's called a judicial foreclosure. Non-judicial foreclosure is done on mostly trust, on the deeds of trust. Remember when I said that the trustee has two obligations? One of them was to foreclose. Well, the trustee is given powers by virtue of that deed. Remember that deed that they have, deed of trust, legal naked title. They start the foreclosure, no government intervention, well, there's government intervention, but no court intervention. But the foreclosure laws, they have to follow the foreclosure laws according to each state. And each state is very specific about foreclosure laws. But they'll take it all the way up to the courthouse steps. They have to record certain things in the land records. They have to record they have to do a posting and publishing. They have to record a notice of default. They have to record a notice of sale. Show up to the courthouse steps. One of two things will happen. Either the property will go to the highest bidder, or if nobody shows up or it doesn't get conveyed, doesn't get sold, the property will revert back to the lender, and now it becomes what's called an real estate owned by the lender, better known as REO. Okay, real estate owned by the lender. So that comes from a trustee's sale. If a lender takes a property back on a non-judicial foreclosure, then that's fine. In most cases, once a deed of trust forecloses, that's it. The borrower is gone, free and clear from that. Yeah, their record's shattered, etc. They lost whatever equity they have, if any, and it's gone. Judicial foreclosure, however, the judge might say that, okay, so the property sold at an auction for $100,000, but you owe the lender $150,000. The judge could say, now you owe the lender the amount of $50,000 still, after the foreclosure has taken place. That's a judicial foreclosure. We don't see a whole lot of that on deeds of trust, because they want to, I mean, judicial foreclosures take a long time. It's very expensive. You'll see that mainly on maybe commercial properties or very high-end properties where there's a lot of money involved. But that's the difference between the two. On a deed of trust, there's generally no judicial foreclosures, although they can. But on a mortgage, you're likely to see that in that particular case. Who's first? Who's on first? Who's on second? I don't know who's on third. First, deed of trust. The way that we prioritize the loans. Somebody goes out and has two loans against the property. In case of a foreclosure, who's going to get paid first? Okay. Well, the way that they work this is whoever recorded first. So if they took out a loan in 2024, okay, and it's recorded, and they take out another loan in 2025, and it's recorded, guess who gets the priority when it comes to foreclosure and all the proceeds? It's going to be this, what they call the senior lien. The person who recorded first is known as the senior lien. The person who recorded second or last in line is called the junior lien. They're junior to the senior. Okay. There is one exception to that, and that's when the first agrees to become subordinate to another loan coming in. There are certain circumstances where the lender says, okay, yeah, you owe me a little bit of money, but I see that you want to make a big deal in the second, so I will give up my place as first. I'll become second, even though I recorded first. And that's done by a document called subordination agreement. So just understand the subordination clause on that. A couple of terms you need to know. Blanket loan, you'll get that question, is a loan that encumbers several properties, two or more properties. Okay, it's not just one property. That's a blanket. You can read those on your own as well. Open end, I mean, that's not something that needs a whole lot of explanation. Lending institutions, we have the Federal Reserve System, the Feds. God bless the Feds. They kind of determine what happens to our interest rates in this business, and all over the world, really. They have a lot of power, and they're supposed to be separate from any political administrations. They're not, but they're supposed to be. And there is a, who makes most of the loans? Well, there are several types of lenders that are going on out there. We have commercial banks, thrifts. They're the largest single resource for residential mortgage credit, by the way, according to this. Insurance companies, you'll see insurance companies financing things like construction loans, in building, that sort of thing. And private individuals, you can get a loan from a private individual. That's also a source. Mortgage brokers, well, mortgage bankers, let's start with that. Mortgage bankers, and that's a huge part of the market, they'll make a loan and they will sell it to the secondary market. They won't keep it, okay? They're going to sell it right away. In fact, the loan is sold before it's even, once it records, it's sold right away into the secondary market. Who do they sell it to in the secondary market? You've heard of Fannie Mae, and you've heard of Freddie Mac, and in some cases you've heard of Ginnie Mae. But Freddie and Fannie, and you need to know the actual names: Federal Home Loan Mortgage Corporation and Federal National Mortgage Association. You need to know the actual name and the acronym. They buy all the loans from mortgage bankers. So the mortgage bankers don't have to wait 30 years to get their money. Then Fannie will take it and they'll do whatever they want with it, either service it or resell it again. There's all sorts of things that a Fannie and Freddie could do. But they dominate the secondary market, as it's called. Because lenders don't like to keep loans for 30 years. That's not what they do. A mortgage broker is a little different. A mortgage broker is a type of broker that has access to many lenders. And they'll pick the best program for the borrower, and they'll send that application to that lender. And they can be a really good deal for borrowers who go through a mortgage broker. They've come a long way, mortgage brokers, and they're regulated, and there are some really good mortgage brokers out there. But they deal with a lot of lenders. They, especially in unusual cases, they know who to go to. We talked about Fannie, Freddie. So this is it, 11:56, folks. And this is, like I said, this is what we do in typically. I do have something else to present to you. This is what we do typically in several days, but we did it in 2 hours today. But let me present something else to you, and I want you to see this. Where is it? Not showing up. Okay, does everybody see this? It's for math problems. All right, this formula here is called MAID-PAID formula. And MAID-PAID, you can figure out 80% of the math problems with the MAID-PAID formula, okay? So I'm going to give you an example. Now let me give you the rules first. The rules are the principal amount will go in the bottom left. That could be a loan amount, it could be the purchase price, it could be an investment amount. That the higher number usually goes on the bottom left. Some type of interest rate is going to be on the right, lower right. Whether it's an interest rate or whether it's a commission rate, it's going to go on the right. Up top is MAID. That's the answer to the question, or one of the answers to the question. So for example, how much money will I make if the sales price is 100,000 and my commission is 6%? Well, if you have two bottom numbers, what do? You multiply. In this case, it's going to be $6,000. 100,000 times 6%. And you take that number and you put it in the MAID. However, you're always going to have 2 out of 3, by the way. If all you had was the question might be, you made $6,000 and the interest rate was 6%. How much was the principal? Well, that, you know, shocks a lot of people. Well, it's very simple. You put the 6,000, okay, that's the money you made in the made section. You put the 6% where it belongs, bottom right, and the formula says do what? 6,000 divided by 6%, and guess what number comes up? 100,000. Okay, or you've made 6,000. The question is, you've made $6,000 in commissions, and the sale amount was 100,000. How much was the commission rate? Well, the formula says 6,000 is above, 100,000 below. What do? You divide 6,000 into 100,000, gives you what? 6%. So you're always going to have 2 out of 3. Now, that could be for investments, it could be for interest, calculating interest, it could be, so they'll tell you the loan amount was 100,000 and the interest rate was 6%. How much interest was made in a year? Well, you multiply the two, same principle. And you could do this as long as you have 2 out of 3, you could answer 80% of the math problems. A lot of people get hung up on math, but I will tell you this, and I don't want you to skip math, but even if you get every single math problem wrong, you could still pass the exam. You could still pass it. But don't do that. Make sure you study it. Make sure that you learn this formula. And like I said, I'm going to be sending everything to you. And that way we'll make sure we have your email. And I'll make sure you get these, not only this, but other things like example tests and questions and answers and all sorts of cool stuff that'll help you in your exam preparation. Folks, I really enjoyed being with you here. This takes me back. It's been a while since I've done this, but I absolutely love it. It's all coming back. Thank you so much for joining us. We really appreciate it. And if we could be of any help at all, please reach out to me, reach out to the person who invited you here, or reach out to me directly. I'm happy to help you. If you're stuck on something, some sort of a question, feel free to reach out to me. My name is Harry Yazbek, and again, thank you for being with me today.
Thanks, Harry.
Thank you so much. Bye-bye.